So far in this series, we've looked at the Anglo-British Constitution, its origins, values and method of development, and we've looked at Magna Carta and the Bill of Rights as examples of constitutional documents, one of the constituent parts of the Constitution. Now we are going to look at another constituent part, law, and more precisely, common law. This chapter will look at the primordial origins of common law in Anglo-Saxon society, and the next and last chapter will look at its fruition in the later medieval period. Now in Chapter 2, I said that the Anglo-British Constitution has no officially defined constitutional laws that take precedence over all other statute laws. Defining such laws is what a codified constitution does after all. Statute laws are simply those laws made by legislators, like the British MPs. This contrasts with common law proper, that is made by the judiciary. There is a little confusion between terms like statute law and case law, or civil law and common law, but I will cover these modern definitions and differences in the next chapter. For now, just consider all Anglo-British law to be genealogically, from history, common law, whether it is statute or case made, because they follow or should follow the same constitutional methodology, like reliance upon precedent or the involvement of the people. We've already seen that the tradition of today's Anglo-British never needed a codified constitution, and one reason was because they created institutions into which they entrusted their values. One of these was the legal institution. Tied with and to the monarchy, the legal institution is probably the most important and successful of the institutions, and of the institutionalizations of the nation. This is no surprise, since law is one of the identifiable values of the nation. Because of this, the law, like the constitution as a whole, does not seek to reach a predetermined place. It relies upon no presuppositions about the good society, nor attempts to bring about a utopian ideal. Hence, it is not constrained by the commandments of a codified constitution. Instead, it simply aims to ensure the equilibrium or fair peace of a society made up of individuals that need to sustainably coexist. We might call this aim, then, justice. And to do this, the law assesses empirical data of interactions. It draws upon past experience, or precedent, to make sense of current events, and it combines the two to update accordingly, so as to be the best it can be at any one time. And this is how the law evolves. Now, an exact starting date for what we define as common law isn't really possible to give, because the law is an evolutionary process. For a turning point, however, a moment where we can point to the law becoming anatomically modern, most historians will plump for the legal innovations of Henry II in the 12th century. This is the point at which the legal system begins to systematically centralise law to the monarchy via an emerging professional judiciary who will conduct a law that is common and commonly applied throughout the entire realm. From this development is our modern legal system based, and we can trace from it a direct line of legal institutions, legal treatises, legal decisions, and even constitutional documents like Magna Carta up to the present day. However, if we were to look up common law on the internet, you might get a definition like this from the Oxford Dictionary that reads, "The part of English law that is derived from custom and judicial precedent rather than statutes." Now, that's true, but if that is the primary definition of common law, or even just part of common law, then clearly there is more to it than can be found simply in the homogenizing and application of law developed by Henry II. If we want to understand the reasoning and justification and aim of common law, we're going to have to go much further back, all the way back to the Anglo-Saxons. And it is from the Anglo-Saxons that contemporary law traces its first kernel. Ever since, the English have been in one never-ending legal experiment to find what works. So how does this form of law arise? We've already seen that Anglo-Saxon values were political and legal ones, and were practiced in local meetings, courts, and via the particular form of kingship. They saw law as a vehicle not of power, at least not just of power, let's not be rose-tinted here, but also of justice, and they used applied legal decisions as rudimentary induction to create a body of law that was practical, accessible, and of and for society, not just of and for the rulers. For example, although juries as we know them are a later development, the existence of compurgators, oath takers, is one of the precursors of the jury system, whereby the accused may rely upon the oaths of sufficient people to declare them not guilty. The Latin for compurgators is jurators. The Latin for compligators is jurators, though don't quote me on the Latin pronunciation there. Hence, one of the characteristics of common law, stated by the dictionary definition mentioned, is first found here, with the legal decisions of local people acting together in their own community on real cases in real time to create legal judgments and thus law. Nothing about that has changed from the 6th century to the 21st. The oldest Anglo-Saxon laws we have in writing are those of King Ethelbert of Kent, and they date to circa 600 AD. Ethelbert had converted to Christianity just prior. We've already seen that the Anglo-Saxons institutionalised their values into their meetings and courts, and that it would be from these national institutions that they would build their states. It is impressive how quickly this process of formal institutionalisation happens after the Anglo-Saxon conquest of Roman Britannia and creation of the new kingdoms. It shows that the Anglo-Saxons already had a sophisticated legal tradition. The input of Roman Christianity greatly aided this process of institutionalisation by introducing new legal forms and routine writing, as well as providing the clerical class to do it. The first of these institutions was the monarchy, and the monarchies of the Anglo-Saxon kingdoms appear to have been happy to adopt the pretensions that Roman Catholicism gave them. Unlike across most of Europe, however, the Anglo-Saxon monarchies and kingdoms retained their legal and political culture, because it was their culture, after all. As a result, the legal forms brought by Christian missionaries were filled with Anglo-Saxon values. This bureaucratizing effect of Christianity helped to solidify the elective nature of Anglo-Saxon kingship, thus helping to make the monarchy a legally, constitutionally defined institution, and thus not absolute, or at least not arbitrary. This effect would help the later English to remember the notion of a model of government based upon legitimacy and nation, rather than simply power or ideology or technocracy. There is clear evidence that Anglo-Saxon monarchy was seen as an accord between king and people. One of the ways that we know the later English defined themselves by their political and legal values is that throughout history they have repeatedly made it a red line for any incoming monarch. This has been most obvious when a foreign-born monarch has come to the throne, and whether it was the Danish Canute, Norman William I, or Dutch William III, all are asked to rule the English by their own laws in return for the throne. There is thus a constant tradition that English values are for everyone, if everyone will accept them. The survival of England as a distinct political, legal and cultural entity owes much to this values-based model of migration, and clashes strongly with today's model that views migration as purely an economic question. You can see this tradition living on in the Brexit vote, in which, on the whole, Brexiteers were clear that they were willing to take an economic hit for the sake of other values and control of migration via the choice of the inhabitants already present. I think it was the journalist Peter Hitchens who once said of the Blair government, "Did they ever ask the people if they wanted this revolution?" This link between sovereignty, democracy and values is no coincidence, and I think it belongs to this ancient tradition. For the most part, foreign monarchs were happy to take the English bargain, to reiterate English law in exchange for the throne. It was the smart choice. The English model of national-based governments has, in retrospect, proven itself to be highly durable and prosperous. Even when this bargain was made flippantly by the incoming monarch, the mere act had the effect of preserving the law for future generations. Indeed, it is interesting to note that the popular idea that history is one long struggle against central government for constitutional and legal responsibility is a myth in England. The English monarchy actually ensures that the Anglo-Saxon tradition is not replaced by a Roman one, and it becomes the guarantor and purveyor of responsible power. To be clear, I'm not saying that this was out of the kindness of their heart, but again and again we see that the monarchy or central government is at least as important for preserving the idea of responsible governance as the aristocracy or the people. Even when the monarchy is behaving tyrannically, it is often brought to heel on the basis that it is not following its own constitutional rules. Thus, the connection between monarchy and law ensures that the latter becomes, perhaps, the number one vehicle of the English nation, something that all generations of all backgrounds and interests could trace and point to as the legitimate tradition of all English and later Anglo-British. The values of Anglo-Saxon legitimate government and communitarian-style law are recognised by the best monarchs as a bargain worth upholding. The development of the legal tradition from Anglo-Saxon times onwards becomes a serious endeavour to work out how to make those Anglo-Saxon values practically work for a growing state. After all, It is one thing to have values, and another to make them work. History is replete with idealistic values and failed systems built upon them. It is the way of history that the Anglo-Saxons were the people that happened to begin with realistic values. Values that it would turn out were closely aligned with how our human society can sustainably function. Realistic values also need the care of institutions that are genuinely and pragmatically tied to protecting those values, and a way for the institutions to actually act on those values. And this is very rare. Often do societies form on the basis of a set of unrealistic values with impractical institutions and a failure to integrate them into society in a harmonious way. The result is that the contradictions, or the misalignment with reality, as I'd prefer to say, become more and more exaggerated and frayed until they snap. Anglo-Saxon monarchy was fortunate to not suffer from this. He had the task of implementing and protecting Anglo-Saxon values that worked, and because of the idea of legitimate kingship, it was personally tied to those values and the responsibility of seeing them carried out, whilst in turn the people were happy to acquiesce precisely because it was legitimate power. I think you can get a feel for the importance of this if you contrast it with, say, some random modern-day parliamentary committee, which no one has ever heard of, which spends a good long time talking about some riveting issue, going on for far too long, usually coming to naught, and all without accountability whatever the results. It's a symptom of a form of governance that has become bloated and is finding jobs to do for itself, and thus accruing unnecessary power to itself. Well, it is because the Anglo-Saxon English get things right at the very beginning in this crucial way that the English as a nation defined by values are able to survive the Norman conquest, why the English is still a constitutional monarchy today, why the country has traditionally seen off the very kind of political extremes that fail to do what the Anglo-Saxons did, and indeed why a majority voted for Brexit, because they were unwilling to risk an alternative form of politics and law in the EU that simply doesn't have the CV of the Anglo-Saxon form. Even the brutal and cavalier Normans, and believe me, William I was one brutal man, even they recognised that the English system paid dividends. That it paid to be a constitutional monarch at the head and accountable to a nation, rather than an absolute monarch at the head of a series of fiefdoms, which are themselves headed by the people who simultaneously are supposed to win your wars and who also want to replace you. A monarchy that helps preserve peace and contentment among the people is stronger and more prosperous, and from this motivation comes a legal system that is genuinely interested in doing this, because justice is conducive to a functioning society. If law is only about the will of the ruler, then there is no incentive to avoid miscarriages of justice. Better to burn two and catch the guilty than burn none and miss the guilty. All that matters is that the will of the ruler is enforced. Justice is neither here nor there in this system, and the innocent must burn if that protects the ruler's will. But even later, when common law becomes truly common via centralisation, it still makes use of local people, making their own judgments in their own vicinities via the jury. Common law, as it would later become, is thus a serious state-level law. Hence, 1066 saw England being fought over by the greatest family of the Anglo-Saxons, William the Conqueror, the head of a papal-approved army, and Harold Hardrada, King of Norway, Europe's most famous warrior celebrity. All of this attention was for a reason, and the reason was that England had grown into a jewel of Europe under the English values. Let's have a look then at some of the specifics of law in Anglo-Saxon times, and how they prefigure common law. We would do well to remember how those from a time far more chaotic and violent than our own coveted the English arrangement. Monarchic Anglo-Saxon law began as a way to settle individual disputes for the purpose of maintaining societal peace. No society can survive on the basis of the extreme, self-indulgent individualism that characterises the so-called snowflake and woke mobs. Law, alongside much else, has today taken a turn towards judging not just people's crimes, but also their souls, such as with so-called hate crimes, presumably to contrast with all other crime that is motivated by love. It's a terribly Orwellian state of affairs. In contrast to the tendency we have today of pushing towards universal conformity, the form of Anglo-Saxon laws demonstrates an acknowledgement that there will not be uniform conformity of thought in society, and that people will simply have irreconcilable differences of opinion or interest. Indeed, the whole basis of a hero culture, like the Germanic Anglo-Saxon one, is to be able to prove yourself. This is clear because the laws not only presuppose such disagreements, and even the ways that they will become violent and thus criminal, but their intent is very clearly to give redress only to the violence of the disagreement, and not to the source or motivation of the disagreement. In plain words, these laws don't make windows into your soul. They seek only to re-establish peace where it has otherwise been broken. We are so far removed from this that Anglo-Saxon law seems strange to us, cold even. But as a societal endeavour, Anglo-Saxon law was first and foremost concerned with the blood feud, something that has plagued all societies across the world. In a Roman-style society, where law and political power are explicitly about might, there is no principle to oppose inter-societal violence. It is simply stopped with an arbitrary higher level of violence by the rulers, or indeed some local bigwig. But since Anglo-Saxon kings ruled with legitimate, not arbitrary power, there was a need for society to be held together by the willing compliance of its members. Anglo-Saxon societies in later England were made up of a web of communities that were fairly self-reliant for everyday things, and this included law. The Shire and the 100 courts resolved the vast majority of legal matters, and the king rarely had to personally intervene. However, the kings needed their kingdom, and each community within it, to not be overcome by or disintegrate into personal feuds or power monopolies. It also seems that in some cases, such as with the Kingdom of Wessex, emphasis was placed upon the national, so to speak, commonality, which all shared in by being part of a structured system of political and legal meetings. Hence, the kings made anti-feuding laws that applied to the whole kingdom, at least officially. The degree of application is hard to judge. The Laws of Ethelbert mentioned earlier appear as a series of compensations for harm done against peace and people, with increasing charges for worse affronts. The increase in charge is not on account of worse intent, but worse damage done. For example, for an individual person, cutting off an ear would cost you 12 shillings, but if the person is already deaf in the remaining ear, the charge is increased to 25 shillings on account of the impact of the crime being greater. Furthermore, an eye is considered more valuable than an ear, since we are so visually dependent, and funnily enough the big toe worth more than the other toes. Likewise, we see in later laws how an earl is worth 3 times as much as a general freeman. This might seem strange to us because it appears to value one life more than another, but the point again is that it is payment against the damage done to society, of which, simply put, an earl is less dispensable than a common freeman. The business of heartache and human value is left to people and their god. Replacing blood feuds or murder for murder with compensation also solved other problems. It removed the uncomfortable situation of a king having to potentially execute members of a population for blood feuding when that same population bases its identity upon personal honour and righting wrongs. In short, the greatness of Anglo-Saxon law was to replace societal violence with societal compensation, without creating laws that were unnecessarily expansive or intrusive. Again, we today are enamoured with the idea that the state and law exist for us personally, but the Anglo-Saxons saw law as impersonal, not because we didn't care, but because the personal should be just that, personal. The state has no business making human life into a legal and moral abstraction, and hence the king was the guarantor not of truth or morality, but justice. You can see that Anglo-Saxon law was already a popular matter, a bottom-up concept. It was about society, and it was written in English to be understood by the people. And furthermore, it relied upon precedent, upon induction and evidence. It actually relied upon the legal knowledge of the people themselves. As we saw earlier with the compurgation or oath system, this is not evidence in the sense that we would now accept it, at least not bindingly. But compurgation, or trial by ordeal, and later juries, are all ways to ensure that law was a matter of and for the people, and a good way for monarchs to demonstrate that their laws were not merely tools of control, of authoritarianism, but something for the people and their own good. The system of compurgation and later the jury also helped to institutionalise the concept that English law would operate via empiricism and induction, and help to restrain the authoritarian instincts that can creep into law. To be clear, the compurgation system and trial by ordeal were based upon divine law, which is simply to say it was in the gods' hands. Now this is obviously defective, and for the same reasons ultimately that natural law is, and hence as empiricism has improved, so has law been able to move away from this. Remember, for today, that everything is always in the hands of the human. Hence those systems which act as if they are neutral or beyond the human, that cite divine or natural law, are all the more suspicious and susceptible to corruption or abuse. But in 600 AD, they didn't have CSI, and we ought not to mock them for what appear to us silly proceedings, nor miss the forest for the trees, that they were simply trying to have a legitimate legal system just as we do. In fact, it is from this endeavour towards legitimacy that our legal system ultimately comes. Hence, early Anglo-Saxon law was once supported by the gods, and then God with Christianity, to give final credence to the oath or trial by ordeal. Certainly the oath system relied upon an internal conscience motivated by religion, which sounds very flimsy, and perhaps is, but it was the best they had. Today, modern empirical methods for discovering evidence give credence to our legal system, hence the evolution of the system. Hopefully you've seen then that the fundamentals of relying upon empirical evidence, oaths, precedent, local knowledge, and upon induction, judging matters case by case on their own merits, from below, not above, can be found in Anglo-Saxon times. The judgments of the people would develop the character of the law, each inductive decision refining existing law, and becoming used as precedent in the future, passed down generation to generation. This system has been so successful that to this very day, witnesses in court will still swear an oath, usually still to God, before giving their testimony. Clearly then, common law has its origins in these times, where we can find defining traits. As the constitutional historian Frederick Maitland says, found within the earliest Anglo-Saxon laws is the legal machinery on the carrying out of which the discipline of self-government is based. This is no small thing. The law was central to creating an English nation-state and staving off feudalism, or the worst excesses of it at least, and subsequent notions of self-determination, from Henry's break with Rome to the logical breakup of the British Empire, and to Brexit, all have their origins in this. In the final chapter, we'll look at how the fundamentals of Anglo-Saxon law developed into the medieval period, until they finally become common law under Henry II.